All right, August 28th, we're finally getting the release of Coyote versus Acme. If you're not familiar with the film, it was originally produced by Warner Brothers. They shot the film, like $30–40 million, and then ultimately shelved it, became like a tax write-off, and then we're gonna release it kind of like the Batgirl movie. And then another independent company, I believe it was Ketchup Entertainment, picked up the movie, purchased it. It's coming out at the end of this month, August 28th. Really, really excited about this. It's gonna be a legal drama, courtroom drama, basically going through the history. It's a civil suit with Coyote suing Acme, big corporation, little guy attacking a big, giant, mean corporation, right? So really, really excited. I'm gonna break down the case. And I've had the pleasure of finding an actual case brief back in the 90s. It was 1991, was tried out in the United States District Court of the Southwestern District in Arizona. All right, that's where this case was tried out at. An actual judge from Texas actually wrote this. It's satire, but he wrote this this opening statement representing Wile E. Coyote and breaking it down for him, helping him like, hey, look, creating the argument for this case of why he's suing Acme, and you know why the Acme could be at fault here. So basically, I'm going to break down what is going on with this case, what you can expect to see in this movie here. Wile E. Coyote is suing Acme basically for, hey, I purchased these products on multiple occasions, and each time I purchased these products, they either malfunctioned on me, they didn't do what they were advertised to do. They not only didn't help me capture the Roadrunner, they end up taking me further away from my goal here and creating more harm, costing him lots and lots of money. So let's break that down. All right, facts of the case. Plaintiff Wile E. Coyote is a self-employed predator who resides in the state of Arizona. All right, that's where this case is being tried at. His occupation requires him to capture and devour prey, including rabbits, mice, birds, and ultimately, the Roadrunner. And he purchases these products from Acme to assist him in these tasks. So Mr. Coyote purchased various high-powered products from mail order company Acme. And according to the opening statement, Mr. Coyote purchased these products from Acme on 85 separate occasions. That's a lot, so we're talking like high-powered rockets and skates and giant slingshots and things of that nature. You can look it up, the products yourself. Mr. Wile E. Coyote was very, very diligent in trying to capture this Roadrunner. Okay, the procedural history on this case. So Mr. Coyote states that on December 13th of 1990, he received a parcel from the defendant, the Acme rocket sled, one of many products he's purchased over time, but this is an example of what happened here. So the intention of Mr. Coyote was to use the rocket sled to aid him in his pursuit of his prey, that prey being the Roadrunner. Mr. Coyote removed the rocket sled and prepared to sight his prey. Mr. Coyote claims that the sled did not have a fail-safe, as Mr. Coyote gripped the handlebars. So imagine that, the rocket sled accelerated with such sudden and powerful force as to stretch Mr. Coyote's four limbs to a length of 50 feet. Okay, I'm reading this forward here. Subsequently, the rest of Mr. Coyote's body shot forward with a violent jolt, causing severe strain to his back and neck and placing him unexpectedly astride the rocket sled. According to Jerry Buckheimer, a federal district judge in Texas, the rocket sled disappeared over the horizon at such a tremendous speed that it left a diminishing jet trail behind it. The sled soon brought Mr. Coyote alongside his prey, that being the Roadrunner. At that point, the animal suddenly veered sharply to the right. Mr. Coyote tried vigorously to follow, but the rocket sled poorly designed steering and faulty or non-existent braking system made it impossible. Shortly thereafter, the rocket sled's unchecked momentum carried it and Mr. Coyote into the side. Okay, so here's the part where we get to the financial part of this, what Mr. Coyote is seeking in this case. Mr. Coyote seeks compensation for personal injuries, lost business income, mental anguish, medical expenses, and meal expenses, because he ain't eating, he ain't catching a Roadrunner, allegedly resulting directly from the Acme company's actions or gross negligence. In connection with his products, he states that on 85 separate occasions, he purchased products from the Acme company through its mail order department, and that certain of these products caused him bodily injuries because of manufacturing defects or inadequate warning labels. Mr. Coyote further asked the court to consider the broader economic consequences of Acme's conduct and award punitive damages in the amount of $17 million. That's not including what his lawyer is asking for, on top of other expenses. So I was cut off there. So imagine that $17 million in 2026 money. I've done the math on that, but it's probably triple what it's worth now. So he's probably asking close to like $100 million now, right? In 2026 money, maybe the movie will cover that. But that's what, according to Mr. Buckheimer, what Mr. Coyote is seeking in damages. So let's get to the legal issues here, the legal arguments and the issues of this case here, starting with the defendant being Acme. Is Acme a monopoly here? Are they negligently selling unsafe manufactured goods to its clientele base, right? Are they acting in good faith? To the plaintiff, did Mr. Coyote have other options to help him in pursuit of the road runner, right? Because Acme would probably argue like, hey, you didn't have to purchase our products. You guys could have, you could have used your animal instinct to catch this roadrunner, and you continued instead to purchase our products and say it's our fault that you didn't catch a roadrunner, and then you being a coyote probably didn't properly read because you can't read, right? You're a coyote. Why would you know? You don't know how these products work. You didn't read the directions. You didn't read the manuscript. Therefore, it's not our fault that the products fail on you multiple times. It's your fault. That's probably what they're going to argue there in the film, I would imagine. And the coyote and the plaintiff, Mr. Coyote, and his representatives are probably going to say, well, hey, look, at the time he was purchasing his products, there was no other options to help me catch this roadrunner, right? There was no Amazon Prime, there was no eBay, there was no, I don't know if, Walmart, whatever sells these rocket power, whatever store, you could purchase something like this in that universe that wasn't existing then. So those are the legal arguments there. Let me know what y'all think. Does Mr. Coyote have a fair legal argument here that he deserves to win his earning or get his earnings from the civil case? If you're an actual attorney that practices civil law and deals with this kind of stuff, I would love to hear a comment from you in this. Or if you're just a fan of Looney Tunes, leave a comment. Remember, hit that like, hit that subscribe button to the most official, unofficial. I'll see you on the next episode.
The number you have dialed has been changed. The new number is, please note, the new number is